Kazubic, initial J, licensed paralegal for the landlord.
Okay, good morning, thank you.
John Sereno, the owner, landlord.
And the tenants?
Maureen Ball.
Paul Peter Bosch. I usually go by my middle name, sir. It's Peter.
Okay.
So if you hear someone refer to Paul or Peter, they're both me.
All right, thank you. All right, so this is an application about non-payment of rent. Is there a dispute about the amount claimed?
Do we have an L1 update?
I'm signing them right now. Last minute again.
There you go.
Thank you.
Here you go.
Thank you.
So the tenants are behind by 3 months, June, July, August.
Okay.
We're asking for a standard order with a section 78.
Okay, we have a number of issues to raise under Section 82 of the Act, sir. And that would be the contents of 3 T2 applications, plus a rather lengthy laundry list of maintenance issues that have not been covered in the ongoing T6 application currently before the board, as well as a number of harassment issues which have come up lately. We're asking for an order that Mr. Sereno and his tenants cease confronting us and harassing us, cease assaulting us, and cease creating noise and disturbances immediately in the nights before a hearing, which has happened so far in every hearing except 2 in this 2.5-year saga. We're also asking for a special hearing block to be assigned to hear these applications. My best estimate at this point would be 5 to 7 days of hearing time for all of this. This has been kicked down the road for 2.5 years, sir, and we're at the point now where we have not had our original T2 application heard. That was filed in March of 2017. This is further
Well,
complicated.
you know that I can't do that because another member is seized on those applications.
No, sir, he is not. Mr. Henry, in the last hearing, indicated that he was keeping only the T6 and that he would be releasing the other applications, the T2 applications, to be heard in whatever order they come up in the docket. And they've not yet been scheduled.
Okay.
Okay, so I do believe that I do have the right to ask that those applications be heard here. Am I mistaken in that?
Member Chair, I would say that the fact that those are different applications, we're here strictly on back rent and those matters.
No, we're not. We're here on Section 82 issues that
Is
have
that
not
the
yet.
application?
I'm sorry,
Is
no,
that a
sir.
copy of the application?
That's the L1 application.
May I see it?
And here's the updated.
Now, I'd like to start by showing
Okay,
videos.
before you
of the
start,
harass-
well, I'm sorry. How much is your monthly rent?
$1139.95.
It's not $11,039.
No, that was something else I was going to raise as well.
Well-
The L1 update is correct, but
Well, yeah, the update form is correct, but the N4 and the application claim $11,039 for 1 month.
as
So-
usual.
The L1 application claims the correct amount?
No.
Not here. Not the one I have, not the one the tenants have.
1139.
Incidentally, Mr. Chairman, there were bed bugs.
They both say $11,229. Bedbugs what, on your table?
Yeah.
Are you serious?
You just
I am. I
flicked
just
one
killed
off
one.
the table.
It's not the first I found in here, but.
Well, I know, it happens, but it's good to let us know.
And landed in my bags.
Yeah, I squished it and clicked it, but it was a bed bug.
Mrs. Ball, could you show Mr. Kazubic your application in the N4? Because it's, I looked at it, and it's the same as the one that's filed here.
And we'd like this application to go forward, so if he needs to amend it, we have no objection.
Pardon me?
We'd like this application to go forward, so if he needs to amend it, we have no objection.
Well, he can amend the application, but he can't amend the N4.
Okay.
But if the tenants are willing to accept the fact that it's a minor error that we can accept and go forward with, that would be beneficial to both sides. So we're not
Divisional
gonna-
court has says that you can't amend notice of termination
That's correct, and I would say for the
So you want to
notice,
move forward without termination?
no, so I do want to go before with termination. I would speak to the
Well,
fact that the error on the
We don't have a
application-
notice of termination that's valid in front of us because this one claims that the tenant's rent is $11,039.95 per month.
Okay. So I would ask that we get an adjournment so we can correct paperwork and serve.
You can't amend the notice of termination.
No, you're correct. So we will withdraw our application and refile.
Okay.
All right, I'd like to say something for the record, Mr. Chairman.
Yes, sir?
The Vice Chair's directive that no more applications be joined into the current mess created by the Landlord-Tenant Board has very strongly prejudiced our interests. This is our landlord's third eviction attempt since that directive was given. He has no trouble at all getting hearing for his applications. Now, our applications are alleging some of the worst behavior possible for a landlord under the Residential Tenancy Act. And Mr. Chairman, the staff at the Combat Training Center at CFB Gaystown were very careful to teach me the principles of fundamental justice. And what I'm seeing here bears no resemblance whatsoever to that.
I would ask that you also explain to the landlord when a legal aid representative or paralegal accepts something, what was it called again?
What, an undertaking.
Thank you, for
Mr.
rent,
Giz, is
that
it
he doesn't sit there and harass us again.
You issued that order that his second representative of four now, Ms. Greenway, she accepted as an undertaking that she would accept rent payments. However, Mr. Serino sends his brother around every month to harass us for rent. He seems to feel that since Ms. Greenway is no longer working for him, that she's off the hook on that undertaking. And I have tried numerous times to explain to both Augustino and his superintendent, Richard Pollington, that's not the way it works. That's why we're here today.
Because we're sick of the harassment to pay rent. He agrees to this
And
and
other
then he comes
reasons.
back at us again.
And that's not the first
I-
consent order he's
Okay.
tossed in the garbage.
I understand your concerns. It may not seem like it because you come here and I have many files to deal with, and it's just one of many. But I understand your concerns. And in fact, I agree with many of your concerns about scheduling. But there is not anything that I can do about applications that are not before me. I would suggest that you take your concerns about scheduling and about how long it has taken to have your matters heard. If you're not getting a response from the vice chair, then write to the chair of Tribunals Ontario. People have done that before, and it has, on occasion, received some sort of response. That would be my suggestion. I understand your concerns with respect to the other applications and the undertaking that was taken and the number of paralegals that Mr. Serino has gone through and the number of times that you've come here. The last two times that you were here before me, the landlord's withdrawn the application.
Yes,
So
and that's what he
what I can do is I can consider the issue of costs.
I would very much appreciate it if you would make Mr. Serino pay for his fund. I'd also like you to reconsider your order on the last L2 application because I can prove
Well,
that.
I'm not dealing with anything that was, any files that were before me previously on which I've already issued orders, and I'm not dealing with any applications that are before me. You may request costs for this application and for today's appearance.
Definitely.
Yeah, every dime you can, please. The only way this guy stops is when it costs him money.
All right, well, you work,
Yes, I do.
and your daily wages,
I declined to sing in front of Mr. Serino.
okay, well, you have to give me an amount that you're asking for, otherwise I have nothing to base it on.
Call it $100.
Okay.
I
And
work
Mrs. Small?
part-time.
All right.
I would ask, were you both scheduled to work today?
Yes.
Yes.
Okay. And is there proof that you're scheduled to work today?
Would you like me to phone my boss on the
Yeah,
spot?
We'd be happy
A
to.
letter of confirmation, I would ask for that to justify costs. So the fact that there is a minor...
Well, I'm not going to put it over,
No,
Um,
sorry.
and I'm not going to...
Mr. Serino is well aware we work.
I'm not going to seek post-hearing submissions on an issue of costs.
Okay. With the application error, it's done... The relationship between the tenant and the landlord is very poisoned currently. and under duress and under fear of making mistakes, it caused them to make a mistake. The fact, the fact that my client has gone through multiple paralegals and you can see that the last paralegal made errors, he shouldn't be punished for something that a professional was trained to do. To award costs today would be prejudicial to my client based on the fact that he's also out of money today, substantially more than the tenants are.
Excuse me.
We have substantially
You don't need to
less.
respond to that.
I say that respectfully.
I understand what you're saying,
Okay, thank you.
but I think your submissions have inspired me to also consider board costs.
Thank you,
Thank
Mr.
you.
Chairman.
Because, I mean, this is ridiculous. This is the second time in what, a month or two?
A month,
A
yeah.
month that the parties have come here only for the application to be withdrawn.
The issue is...
It is obvious on its face that the notice and the application are wrong.
Sorry, the issue is the fact that this is back rent. This is not other applications where it's harassment.
The issue is not this is back rent. The issue is that the tenants were given a notice of termination that is clearly wrong on its face. The error was copied onto the application. The tenants were brought here. This is about the second time in a month that the landlord has brought the tenants to the board only to withdraw the application. The only benefit now is that this is happening within the first hour, whereas last time I think they waited until about 2 in the afternoon for it to be withdrawn.
Yeah.
I would say that they agreed that there is back rent owing. This is not a frivolous application. This is back rent. Today's application is strictly on back rent that they agree is outstanding.
$11,039.30.
But they did accept the fact that they would accept to amend it, which acknowledges the fact that they're 3 months behind.
Yeah, but you don't want to amend it because you want the termination.
Correct.
Right. Okay, and instead you're choosing to withdraw.
Mr. Chairman.
All right, I will order $150 for the tenants for the day and $150 board costs. And Mr. Serino, you may not file any other applications until that's paid.
Thank you, Mr. Chairman.
Yeah, you know what, let's take a break then. Yeah. Okay, I'm going to take a break so that staff can come and